ICJ Canada was established in 1958 under the leadership of the president of what was then called the Exchequer Court of Canada, which is today the Federal Court of Canada. And its primary objective, which is very relevant to this award and to this award recipient, is to promote, protect, and strengthen the rule of law, and in particular, the independence of the judiciary and legal profession in Canada and around the world. Les objectifs de l'organisation sont d'unir les avocats, les juges, les membres de tribunaux administratifs au Canada dans la continuation de ces principes-là et de maintenir les plus hauts niveaux d'administration de la justice dans le but de protéger les libertés fondamentales et les droits des individus sous le système judiciaire. So the aims of the ICJ Canada are to unite lawyers and judges and administrative tribunal members in Canada in the maintenance of these principles and to assist in the maintenance of the highest standards of the administration of justice with the view of ensuring the fundamental liberties of the individual under the law. And that very much includes access to justice, which is going to be a theme of this evening's talk from Paul Champ. ICJ Canada is also part of a global international organization, the ICJ Geneva. And the vision of ICJ Geneva is a world in which a just, democratic, and peaceful society is achieved through the rule of law, the arbitrary exercise of power is prevented, rights and freedom are expanded, and social justice is embraced. And I would argue that those goals and this vision is one that is deeply shared by jurists in this country, and that is an indication of your presence here and your support, and those values very much personified by this year's winner, Paul Champ. The activities of the ICJ Canada are really to be a home for judges, lawyers, academics, and law students who want to contribute to these objectives at home and abroad. We organize a speaker series all over the country that we aim to make available to all of our members through our website, through webcast. We organize conferences on the rule of law, the independence of the judiciary, and human rights. From time to time, some of our members participate in missions abroad for the ICJ Geneva and report on these missions here at home. One recent mission was from Justice Binney, who is our ICJ Commissioner in Geneva, who went on a mission to Egypt for the ICJ to look into their justice system, report on their justice system, and his report here in Canada very much some 6 months ago, very much foreshadowed the events that we see today, and his role with the ICJ Geneva was able to give him a lot of access to very senior members of the judiciary in Egypt. We work with like-minded organizations on areas of common interest. We welcome eminent jurists from the international sphere to Canada to bring their experiences. And we indeed are part of the leadership of the international organization with Justice Binney and Michel Rivet, two eminent Canadian jurists serving as ICJ commissioners. And something else that we do is we award the Walter Tarnopolsky Award for outstanding efforts in the field of human rights, which is why we're here tonight. This award is given each year to a Canadian who has made a major contribution in the field of human rights. Recipients are selected by a committee comprised of representatives of ICJ Canada, the Canadian Bar Association, the Canadian Association of Law Teachers, and the Canadian Superior Court Judges Association. So really, when you win the Tarnopolsky Award, you are recognized by the judiciary, by academia, by the bench, and by your peers in the human rights and legal field. It is a major award. Past recipients of the award include Irwin Cotler, Ed Broadbent, the late Justice Mark McGuigan, Gordon Fairweather, who was the very first Chief Commissioner of the Canadian Human Rights Commission, Joseph Harvey, Wayne McKay, Gérald Baudouin, Georgette Gagnon, Rosalie Abella, Marcia Cran, Errol Mendez, David Mattis, Yves Fortier, Jane Stoyles, who I understand is here with us this evening, James Orbinski, and Elise Groux. This year, it's my great pleasure and privilege to present the award to an outstanding and passionate advocate for human rights and social justice, Paul Champ. And I want to say a few words about Paul. Many of you know him, and he is indeed well known to Canadians who follow human rights issues, social justice issues. We read about Paul in the newspaper. We hear about Paul reading cases. His impact is major, and it is very much a positive one in terms of access to justice, rule of law, and independence of the bar. He has graduated from Carleton University with a Bachelor of Journalism and from UBC with a Bachelor of Law. And to me, it's interesting that those two disciplines are quite evident in Paul Champ's advocacy, in Paul Champ's successes. And indeed, we see his social justice and human rights law practice now starting its fifth year of operations. And we have seen Paul make legal and media headlines in a number of precedent and groundbreaking human rights cases. I'm not going to talk about all of them, but just wanted to list a few. He represented Amnesty International and the British Columbia Civil Liberties Association in the inquiry on Afghan detainees. We've all heard about this case, hugely important, and Paul's involvement led to the signing of a new agreement with Afghanistan to monitor prisoners. Over a period of 6 years, Paul has worked over 2,300 pro bono hours in this matter alone. He's been involved in Canada and Qatar, where the Supreme Court of Canada ultimately found that Canada had breached the Charter by interrogating a Canadian youth detained in Guantanamo Bay, Cuba. He was involved in the matter of Abdul Razik and Minister of Foreign Affairs Canada, where the court found that Canadian officials had violated a citizen's charter rights by arranging for an unlawful detention by Sudanese authorities and refusing to provide a passport. Again, a case that made legal and media headlines. Il a été impliqué dans l'affaire Attaran contre ministre des Affaires étrangères, où la Cour a reconnu que la discrétion d'un organisme gouvernemental de refuser la divulgation de documents en vertu de la loi sur l'accès à l'information devait être exercée de façon à être conforme aux objectifs de la loi qui sont de favoriser la transparence. Paul was involved in a matter of Chuck and Hud Bay Minerals, Inc., where the court found that a Canadian mining company can be sued for human rights abuses allegedly committed in Guatemala by security personnel working for a subsidiary. So hugely important in terms of corporate responsibility. More recently, the matter of Paget and Mulcair, also a politicized and mediatized issue where the parliamentary budget officer was found not to be barred by parliamentary privilege and able to go to court to compel production of documents from government institutions. Again, access to information, access to justice. And I want to mention two last cases. One, Pictou Landing Band Council in Canada, where the federal court recently found that a very important principle called Jordan's Principle, which is a child first principle for the provision of service to First Nations children, was found to be justiciable by the federal court. The federal court found this principle and agreed with Paul's submissions that this was something that can be enforced. And lastly, Paul was involved in the case of John and Ontario Ministry of Corrections. And this case led to a public settlement where Ontario agreed to sweeping policy changes designed to eliminate the use of solitary confinement for provincial inmates with mental illnesses. Paul has, on top of all of those groundbreaking cases, has taught courses at the University of Ottawa on the law of armed conflict and social justice and the law. He's a frequent speaker on topics relating to social justice, human rights, laws of war. He contributed to very much realizing the vision of the ICJ Geneva, which is a world where access to justice, rule of law, independence of the bar are made real. He has truly earned this year's Tarnopolsky Award, and it's an honor to present it to him this evening. Thank you.
Thank you. Thank you. That's great.
To you.
Thank you.
Oh, yes.
Thank you very much. I'm told I have about 20 minutes to entertain you. I'd just like to say that it really is a great privilege and honor to deliver the 2013 Tarnopolsky Address on Human Rights. This evening, my speech is entitled Challenges for Access to Justice in Human Rights, the Practitioner's Perspective. Some of you here aren't lawyers, obviously, but I think the idea of access to justice is well understood. It's about concern that people cannot access legal systems because the legal system is either too complex or they can't get proper legal representation. This should be a concern for all society, particularly when it comes to human rights, which are fundamental to Canada. Many eminent judges have spoken about this topic, from the Chief Justice of the Supreme Court of Canada to the Chief Justice of the Ontario Court of Appeal. So it's a very timely issue. I'm going to speak about it in the context of the area of law that I practice, human rights. I'll talk a bit about the human rights system in Canada, filing human rights under human rights codes, human rights legislation. If I have time, I might talk a little bit about some of the national security and civil liberties cases that I've worked on and the access to justice obstacles that are presented in those cases. But I'm going to focus primarily on human rights legislation, the Human Rights Act, Ontario Human Rights Code, and comparable legislation across Canada, and the problems that people face in trying to bring those cases. But before I do, I just need to say a few brief thank yous. Thank you, obviously, to the selection committee for choosing me for this award. I'm deeply honored to be recognized in this way, knowing that the committee is comprised of judges and law professors and other eminent lawyers. I mean, I work in a very small law firm in what is a fringe area of law, really, human rights. So I'm honored to know that our work is sometimes even on the radar of people who are on that panel. And make no mistake, human rights is a fringe area of practice of law in Canada, which is a real shame. And how do I know it's a fringe area of practice? Well, every year when I file my documents with the Law Society and my legal insurer, when they're canvassing what do I do and am I properly licensed, we've got forms that have like 25 boxes of areas of law, and human rights isn't on there. I don't know what's with that, but anyways, you can check. So there you go, and thank you. I also want to thank all of the colleagues that I've worked with over the years on many of these cases, because everyone knows that no case rests on one person's shoulders, and those who work with me know that's definitely not the case. The legal assistants and the lawyers and the students who've all worked with me on these cases over the years, the massive document dumps and the huge court records and the last-minute factums, too many to count. I just want to thank all those people I work with who share the same commitment that I have to human rights, for your great ideas and your patience and your continuing support. And of course, then also thank you to those who organized this event tonight, Philippe Defrain and Pat Whiting from Carleton University. I want to thank everyone there for organizing the evening. So, access to justice. Access to justice means really just making it easier for people to access the legal system, to obtain a remedy for a dispute. And generally, the access to justice problem is seen as unnecessarily lengthy proceedings, costly proceedings and complex procedures, and then also exorbitant lawyer fees, putting justice out of the reach of average people. And for human rights, in the area of human rights, I see it both as a problem of access and justice. There are barriers to getting access to that system, and then the justice that you get, in my opinion, too often trivializes human rights. I don't think that we have robust enough remedies at all for human rights in Canada. I think that's why it's not respected enough. I can say this, that in the cases that I work on, too often I feel that I have to tell people it's not worthwhile. It's simply not worth the sacrifice for them to try to enforce their rights and get that vindication and restore their dignity. And amazingly, a lot of them say, well, I'm not worried about the cost, and let's see what we can do, because the principle is far more important. And so that's often what we do, and that's also another group of people that I obviously have to thank, is some of the many clients that I've represented who are so brave to bring their stories forward and seek vindication through the tribunal systems. So I'll try to just explain a little bit the human rights system that we do have in Canada for those who don't understand it. The process is generally you file a human rights complaint under the relevant human rights legislation, whether it's provincial or federal, and it deals with employment or services or accommodation. But the process itself has changed many times over the years. There's been a lot of reforms to try to improve it in ways, and I just don't think it's quite done the job yet. When it started about 50 or 60 years ago, human rights legislation was enforced as a quasi-criminal process. It was prosecutions by the state, and there would be quasi-criminal penalties. But the criminal threshold for conviction was so high that there were very few cases that would go forward, like very few. This changed in the 1960s and 1970s, with jurisdictions across Canada adopting special bodies to deal with human rights. They would no longer go to courts, and the bodies that would deal with them were human rights commissions and human rights tribunals. Now, this system that we had in Canada for several decades is what's sometimes called the gatekeeper system. And if you don't know the difference between a human rights commission and a human rights tribunal, don't worry, because I've encountered some judges who didn't know either. I recall one judicial review I did of a judge who used to do maritime law, and he appeared, and I started my case launching into this decision. We're challenging the commission, and he started, he goes, whoa, Mr. Champ, can you just tell me what's the difference between the commission and the tribunal? So I knew I had a bit of work to do that day. But the way it works is that the commission is a gatekeeper system where you file a complaint with your Human Rights Commission, and the Human Rights Commission investigates it, and they decide if it has merit, and if it has merit, then the commission decides to refer it to a hearing or adjudication before a tribunal. And then when you go to the tribunal, that's when it's more like a trial or a courtroom where you have adjudication and witnesses and then a remedy. And, and at the point that it's referred, at least theoretically, the commission is supposed to change hats. From being a decision maker on whether your complaint has merit, they then change hats and become a lawyer or a party right in the system, right in the tribunal where they're supposed to represent the interests of the complainant. Now, in theory, this was great for access to justice. A person who believed that they were a victim of discrimination had to do little more than just file a complaint with the commission, and the commission would pick it up. They would send out investigators. They'd go to your employer and force them to produce documents and interviews and so forth, and then they would refer it to hearing, and then they would move to a lawyer. A commission lawyer would represent you in that process. And all the way, the victim had assistance and support and didn't have to pay a dime in legal fees. But this great system had many problems. First, the investigations themselves became very lengthy and complex. And second, the decisions that were made on whether to refer your complaint or not were often made or recommended by investigators who are rather lower level officials who have some training, but they're not lawyers, and they're certainly not judges. And you're seeing someone's fundamental human rights being essentially decided by someone without any kind of hearing, without any legal training. So you had people who had complaints that were dismissed without any form of hearing at all. And I cannot count the number of cases that I've seen and some I've worked on where the Canadian Human Rights Commission, for example, will investigate a complaint and dismiss it, saying there's no merit there. That person doesn't even have a scintilla of a case to go to hearing for the tribunal. And that decision is challenged in court. The court overturns it, sends it back to the commission for reinvestigation. The commission now decides, maybe it does have a bit of merit, refer it to the tribunal, and then after 2 weeks there's a finding of, this is a flagrant case of racial discrimination or sex discrimination. So you have to wonder, how about all those other cases where the person didn't have a lawyer to challenge it in court? And if that system where the final ruling of a tribunal is in the favor of the complainant, how could it be that a commission would say it doesn't even have a chance? Well, unfortunately, that's the system we had, where many cases were system that we still have federally, where cases were screened out. So this gatekeeper system also offered respondents, that is, the big companies or government departments, many opportunities to block a case from being heard on its merits. If the commission decides to refer a case to the tribunal, the big company or the government department can go to court to try to stop it and say, no, we disagree with that decision, it wasn't done fairly, and so on and so forth. And the person has to try to defend that in court, and the person doesn't have support of the commission when they go to the court, and all the complexity of judicial review procedures before even getting to a hearing on the merits. And then what about the representation by the commission lawyers? Well, as a matter of policy and reality of underfunding, human rights commissions elected increasingly over the last couple of decades not to participate at all in hearings, claiming that it wasn't, quote, in the public interest. That may well be fine, but that's the system we have, where 60 or 70 or 80% of complainants go to a tribunal hearing without any representation whatsoever. And very often they're up against very well-resourced respondents. And these are often, people, the most common cases that you have now before human rights tribunals, or the most common complaints, are from people with disabilities. Disabled Canadians looking to, gain access to services, to buildings, or keep their jobs. They're looking to be accommodated in their job, not to be fired simply because their contributions aren't recognized, and what they can do as opposed to what they can't do is not considered by their employers. And the other thing about disability cases in particular, I do a lot of disability cases, they're very complex cases to run because you need a lot of experts, you need medical experts, sometimes you need occupational therapists and experts like that, and the law around the duty to accommodate is very complex. Again, although it's a fringe area of law, that doesn't reduce the complexity of our area of law. So, this is an individual who will have spent maybe 3 years of navigating their case through the commission system and the commission investigation procedures before even getting to the doors of the tribunal, and there they are alone. And from my own experience, sometimes it takes much longer than 2 or 3 years or 4 years. There's many cases that I've seen take 6, 7, or 8 years before you can get a finding or a ruling from the tribunal. So this process, this human rights process, I would say, with all its good intentions, is not accessible. 5 years ago, Ontario decided to reform its human rights system. They've adopted a new system, and what we've done in Ontario now is it's what's called the direct access model. That means when you file a complaint, the commission isn't the gatekeeper anymore. It goes directly to the tribunal, and away you go. The commission doesn't represent you, but there is some legal support that's provided in some cases, a small number of cases. But as a lawyer who represents individuals in these situations, I like that system because at least I can get to hearing very quickly. I'm not spending 2 and 3 years making extensive written submissions, making 10 or 15 page submissions multiple times, answering pages of questions of a commission investigator, case conference calls, and so forth. We can get to hearing right away. So that means less cost, less time, less cost. So that brings me then to the other big problem, the huge problem in the human rights system, and that's lawyers and legal costs. Obviously, this next part will sound a bit self-serving, but lawyers make the legal system work. The old Shakespearean quote about "first thing, kill all the lawyers" wasn't actually meant to denote or say that lawyers are bad. It was when they were trying to overthrow the state, and when you're trying to overthrow the king and the state, you get rid of the lawyers because the lawyers represent the rule of law. The problem in the human rights system is these human rights tribunals, we have it set up right now, do not award your legal costs. So any successful claimant has to deduct their legal costs from any award of damages that they receive. Now, that would be perfectly fine. Believe me, it would be perfectly fine if damages awards for human rights violations were anywhere close to what you might see in the U.S. system. I was just reading an article the other day about, it was a summary of, an empirical study of damages awards for sexual harassment cases under the Civil Rights Act in the United States. Those cases run on average in between $4 and $5 million. $4 and that's for compensation for pain and suffering and punitive damages. Now, we don't have punitive damages in our human rights system, but in any event, we're talking about $4 million in damages. If I could start getting, even knock 1 0 off that in some of my cases, I would have a very different practice indeed. And this is the other part, is the justice part. There's the access part, and then there's the justice part. And what we have in Canada is a system where awards for damages and remedies for people who are seeking vindication of their human rights is, in my view, embarrassingly low. You know, contrary to the expectation of every single client who walks into my door with human rights case, the human rights awards and damages, when I tell them what they can expect, they're always shocked. They're always shocked. You know, damages for mental suffering and harm to dignity are generally about $5,000 to $10,000 for the federal system, and perhaps $15,000 to $25,000 in the Ontario system. And that's it. And then pay your lawyer out of that. You know, and two common suggestions for improving access to legal representation are contingency fees and pro bono work. We hear judges speaking that, you know, these are ways that we can improve. We, as the bar, lawyers in Canada, can improve access to justice. Now, contingency fees are where a lawyer takes a percentage of the award if you win. But let's say I do even a 40% contingency fee, which incidentally is on the borderline of unacceptable for the Law Society as too high. And I'm representing a client. I spend 2 to 3 years convincing the commission to refer my client's case to the tribunal. I'll have written probably 2 extensive submissions of over 10 to 20 pages each, answered letters with dozens of written questions from the investigator. Well, how long does it take you to write something for 10 pages long? Think about it. And then your case gets referred to hearing. Like maybe this is a sexual harassment case, so I'll call my client as a witness who testifies for maybe 2 days, speaking about maybe 10 different incidents, which is necessary because harassment's about repetitive behavior. It's not just a one-time thing. It's many different incidents. Maybe we call a few other witnesses, a few former colleagues. Oh, and then there's the medical expert, because if you don't have a medical expert, you're not even getting that $5,000 or $10,000. You're not going to get the $5,000 or $10,000 if you don't have the medical evidence which supports your case, which incidentally, if you're lucky and you beg, that doctor will appear for maybe $1,000, which of course you don't get compensated for either. That's the doctor's fee, let alone all my time trying to cajole that person to appear and write them nice letters and so forth. And then, you know, after 3 or 4 days of our case, then the employer will call other witnesses. Sometimes they'll call a medical expert too, calling into question about, was my client really that upset about being sexually harassed? You know, cross-examining her on her medical situation or medical history or psychiatric history. You know, and let's say at the end of that case we win. Yay, great. My client gets $10,000 in damages for pain and suffering and harm to dignity. And for 7 days of hearings, multiple lengthy written submissions, my fee is $4,000. And just as importantly to my client, they get about maybe $3,000, because that's after the taxes and the fee to the doctor and so forth, and the photocopies, so forth. Well, the $3,000 for what? For having to go through a process that took about 5, 6 years, reliving the matter all those years, re-victimized, in my view, in many ways, and then being cross-examined by highly paid and effective legal counsel about her psychiatric history, all for the reward of what? Enough money to, you know, buy a new big screen TV and a stereo. I think it trivializes human rights, and it definitely does not deter companies or big respondents. Are they concerned about those kinds of damages? Not a chance. So contingency fees really don't work in the human rights context. I may as well, if I care that much about it, $4,000 for 4 years of work, I would just as soon do it for free. And in fact, I do. Our firm and the lawyers who work with me, we all get you know, earnings that are far below market, and we do about 30% of our work pro bono. And we're proud to do it. But is that the answer? Is that the answer for vindication of these fundamental rights? You know, pro bono at the end of the day is really charity. And you know, charity means good things and charity gets good things done, but charity is also ad hoc and discretionary. Do we want human rights vindicated in our society primarily on the basis of charity? Is that empowering to that individual? Is that restoring their dignity? You know, I hope all of this should be upsetting to all of you and to all Canadians, because we have to remember human rights cases are not simply private disputes. Discrimination, as our law recognizes, is a public wrong that harms the entire community. Equality is a fundamental value in Canadian society, and it promotes the inherent dignity of every individual. None of us are free until all of us are free. Injustice anywhere is a threat to justice everywhere. While modern human rights statutes authorize the compensation of individuals whose human rights have been violated, their overriding purpose remains to remove discrimination in our society, to eradicate discrimination in society. The filing and adjudication of human rights complaints help create a more inclusive and just society, which benefits us all. For that person, that disabled worker, if they're fired and they're home and they're going on disability, Ontario disability support or something like that, aside from the huge damage to that individual's self-esteem and well-being, that's a damage to all society, because that person has a lot to contribute. That person has a lot of different perspectives to offer. That person has a right to work just like anyone else. You know, and the broader public purpose of human rights statutes is reflected in the remedial powers of human rights tribunals, which include the authority to craft public interest remedies. That's a power in all human rights legislation. So, you know, in many cases, complainants aren't even seeking a financial remedy. Rather, they're trying to secure wide-ranging public or systemic remedies that benefit the wider community. Human rights complaints have been responsible for realizing equal access to critically important services such as voting, housing, healthcare, education, transportation, and social services. They change it. They change the system for those who come after. You know, the recent case that I just settled with Christina Jean, and she is a very courageous individual. Suffered from mental illness all of her life, and had spent over 200 days in solitary confinement because of her mental illness at the Ottawa Carleton Detention Centre. And when the government tried to settle the case, they put a really pretty large amount of money on the table for her to settle. And this woman, who probably, I don't think, has ever had a taxable income of more than $5,000 in her life, I'm sure, and she'd have a chuckle about that, she said no. She said no because she did not want it to happen to anyone ever again. And so we went forward with the case, and ultimately were able to resolve that case in wide-ranging public interest remedies, sweeping changes to the policies across Ontario for all prisons, for anyone with mental illness who might be at risk of being put in solitary confinement. And she did that. She did that. So, you know, the human rights system is about doing more than just resolving a private dispute. It's about vindicating human rights. And human rights is something that we all share. I just want to take a look at my time. Not sure if I'm too far over. One last sort of example, just to sort of drive this point home. The issue of legal costs. In the Canadian human rights, well, because I'll lead us into how can or should things change. And just to, before I reach that last point, I like to point at these two cases that I think really illustrate the problem. In 2011, I appeared before the Supreme Court of Canada with a number of other lawyers on a case involving a former Canadian Forces officer named Donna Mowat. She had gone to the Human Rights Tribunal alleging sexual harassment. She got an award of damages of $4,000. after multiple days of hearing. And at that time, and for 20 years actually, our Human Rights Tribunal used to award legal costs. And so she got an award of $47,000 of legal costs. So $47,000 for legal costs to run the case, but $4,000 for your damages for that sexual harassment. Now, the tribunal the Canadian Rights Tribunal for about 2 decades had been awarding legal costs to counsel, saying that it fell within their authority to do so because the Canadian Rights Act says that they can compensate someone for expenses. And they said, well, expenses, ordinary dictionary interpretation of expenses is cost, so we're going to cover your costs. And that's the way it always was. You know, and it makes sense. You're trying to make that person whole. You're trying to make that person whole. Well, the Supreme Court of Canada ruled against that interpretation in 2011. The Supreme Court in Canada held that a proper interpretation of the Act would mean that expenses would not include legal costs, costs being a legal term of art which could not have been contemplated when Parliament passed legislation saying expenses can be compensated. You know, and part of the reasoning of the court, which I find ironic on so many levels, I'm sure you'll appreciate now from my speech, was that the court said, well, if the limit for damages, and incidentally there was a cap in damages up until 1998 in the federal system of $5,000, it's now $20,000. The court said, and this case had started that long ago, in 2011 the Supreme Court of Canada, she filed it in 1998, said, well, if the cap in the statute is $5,000, how can you have this other provision where you might be able to get $50,000 in costs? It doesn't make sense. Well, I agree, it doesn't make sense. But I think that the analytical point the court missed, they turned it on its head. They should have been working about the access issue. They should have been saying, well, we're going to do what we can here. We're going to interpret the Act the way it can be interpreted. And for policy reasons about promoting access to justice, securing and protecting human rights, we're going to find that, yeah, people can get their legal costs paid so that it's actually possible and not crazy to try to run a human rights case. But they didn't. So since 2011, you can't get costs. I haven't been before the tribunal since on an individual case. And incidentally, on that one, I intervened on behalf of the Council of Canadians for Disabilities because that organization was deeply concerned in particular about disabled people because, as I mentioned earlier, it's people with disabilities who are bringing the most complaints, and those are the most expensive and complex cases to litigate. Well, an interesting thing is that same year, in 2011, the Supreme Court of Canada made another judgment on legal costs in another administrative tribunal. It wasn't a human rights tribunal. It was the National Energy Board. This case was called Smith v. Alliance Pipeline. And Smith v. Alliance Pipeline involved a farmer, Vernon Smith, whose land was subject to expropriation for an easement of a pipeline. And under that legislation, it says, well, if you're not satisfied with what the oil company is going to pay you in compensation, you can go to arbitration to say, I should be getting more money. That's not enough money. I want more money. Well, the arbitrator ruled that not only should he have gotten more money, his full legal costs should be paid, solicitor kind, entirely. And this issue made it all the way up to the Supreme Court because there was also some court injunctions and stuff like that in addition to the arbitration. And the arbitrator said, you know, Farmer Smith should get all of that money, all the money that he spent in trying to fight injunctions and so forth. That would be like, you know, for those of you in the human rights area, like all your judicial reviews and all that, you should get all your legal costs for those because as, you know, those who practice know, you might only get 20% of your costs. Well, that went all the way up to the Supreme Court of Canada, and the Supreme Court of Canada ruled that they could interpret the National Energy Board Act to say that the farmer, the person, the property owner who had his land expropriated, a small sliver of it, should get his full legal costs because he was so vulnerable. The vulnerable property owner. And said that the National Energy Board Act was a remedial statute and should get a broad and liberal interpretation. That's why they know that it should be interpreted that way to make him whole. So there you go, the stories of Donna Mowat and Vernon Smith. What are the answers to the access to justice problem in human rights? Well, you know, my first point is it shouldn't just fall on lawyers. The entire legal system, including the courts, need to take responsibility. We need jurisprudence that matches, you know, the rhetoric that we get from judges outside the court. judgments and their jurisprudence needs to meet that rhetoric. And the other thing is, I also think we need to make it easier for lawyers to practice in this field. When I go to legal conferences or things and I say I'm a human rights lawyer to another lawyer, they kind of look at me quizzically, like I just said that, you know, I'm a platypus or something like that. Because you know, for the most part, you can't. And you know, I'll say this: the energy and ingenuity and strategy that I put in to try to figure out how to make a case work, how to finance it, how to be able to run it, go to the right place, choose the right issues. Don't rely on that issue. Let's not call that one because it'll make it too long and so forth, so that we can push it as far as possible so that hopefully the respondent will either settle or if absolutely necessary we'll take them to hearing. I spend so much of my time doing that. Like I can't even imagine what it would be like if I was litigating one of those big cases where you've got a company that's doing whatever and it's, you know, win the case no matter what, and it, you know, you've got the huge chessboard of your legal system and all the different tools and motions and everything you can do. I can't do that. I can do like one motion maybe, because I can't do more because that's going to blow that case. It's not going to happen. So I'm putting all my ingenuity to that, and I think that we have to make it easier for lawyers to do that. Part of it is, I'll make my little sort of comment on tuitions. You know, when I'm hiring articling students today or young lawyers to come and work with me, aside from the fact that they are, you know, the most brilliant young students and lawyers around who could be doing all kinds of things where they'd be making much more money, the problem is that they are now coming out of law schools with debts that are enormous. They're astounding because law school tuitions in Ontario have been deregulated because they feel, well, all those people who work on Bay Street are making these huge sums of money, so we need to make our tuitions higher to recognize that these people are going to go and make massive incomes. Like I think the tuitions in Ontario, they run from $16,000 to $30,000 a year in law schools. Well, I don't begrudge those people working on Bay Street. That's great. That's good for them. I'm happy for them. But how can I, in good conscience, hire someone who's a graduate of U of T Law School who's paid $95,000 or $100,000 in tuition, let alone all their other costs? It's not feasible for them to work in these fields. So, you know, all the things that I've kind of said about human rights, a lot of the things in terms of access to justice could also be said for a whole range of other social justice issues and fields. That, you know, lawyers making, you know, $50,000, $60,000, $70,000 or even, you know, or less. There's lots of lawyers that make less than that. After paying your rent and everything, we can make it work, but not if people are coming out of law school with $150,000 in debt. So, you know, law schools, I think, you know, University of Ottawa Law School, for example, calls itself the Social Justice Law School. I don't see that when I see their tuitions, and I don't see that when I don't hear them speaking out about legal aid, for example. Do I hear them making special submissions to the provincial government that legal aid should be much higher? Do I hear them speaking on those issues? I don't. And, you know, that's disappointing. It's one thing to corral in all these idealistic young people who want to be lawyers, but I think they have to maybe walk the walk a little bit as well. So I'll just close with this. You know, I believe in the legal system as a forum for resolving these kinds of disputes. I think that even the big ones where we get public interest remedies and change the system, the marginalized and the disadvantaged in our society, they don't have access to Parliament. They have no voice there. But, you know, the courts and the tribunals, they're open. And if they've got, you know, legal representation and just a bit of assistance, they can do a lot of great things. And you know, that enhances the legitimacy of our entire system. Because if we don't provide equality for those groups and those individuals, then I don't think that, you know, we are respecting, you know, the image of Canada that we like to share and project to the world. Anyways, so on that, thank you very much. That's my address.